try to begin with the presentation. We'll get back with Taimoor once he gets in. Hello, and welcome all to the second and the last roundtable discussion on law tech. Today, we will be focusing on the technological aspect of it. So, what is legal tech? Well, legal tech refers to the application of technology to the world of law and automating the tasks that until now have been carried out conventionally by lawyers or other persons working in the law firms. Let alone the digital age, the let alone the law, the digital age have been through like nine big significant shifts, and it's about time the legal industry catches up to it. So let's just see what shifts we have been through in the digital age. There have been shifts in the ways of working, waterfall to agile. Everything is about speed and deployment, and it is basically the new norm. And then there is no perceivable boundaries between tech and business. Business is basically run by tech. It's with tech, it's an ecosystem that values creation but also jointly shares the risk. There have been shifts in resources where AI and robotics have created new jobs, rendering the traditional jobs go obsolete. Now organizations are adopting the vision and culture required to build the build the digital DNA. Industries undergo innovation and experimentation, which in turn requires a fit governments and management. There have been shifts in technology, cloud and IT is remotely accessible, and processes are being automated with zero human intervention. Business and data analytics are fueling the algorithmic business, giving it a competitive edge. IT and OT are converging, and today basically they mean the same thing. Let's also acknowledge the gap which we have today and why we are here to discuss. So there is a huge gap between what society demands and what the legal industry can offer today. If the technologies and the digital age were utilized to their full potential, lawyer will be better equipped with the knowledge and expertise to operate better in the legal landscape of the future. Also, like the educational programs today don't anticipate the major changes that the digital age is being going through, and they also need to go under through the legal landscape of changing. So now I'll hand over the slide to William. He will be talking more into the technologies that play the current major roles in legal tech. Over to you, William.
Thank you. So I'm just going to be covering a very brief overview of the technologies. I'm not going to go very advanced on these. So the first is blockchain. Most of you probably are aware of it for its cryptocurrency like relations. However, because it's immutable, anything that's recorded to it is a permanent record. In addition to it being spread out, and it's also confirmed by the other nodes on the system, it means that it can be used in a lot of different situations. So such opportunities could be that it could be used in smart contracts for validations and verifications of people viewing it. And that can also be used in the chain of custody of evidence or for intellectual property. And as with cryptocurrency, transactions, any payments can also be verified, and it can also allow for the decentralization of data, which can also then lead to some challenges. Vikalp, can you skip forward? I think you missed one slide as well. If you could. So the challenges is the next slide. But with it being decentralized, that does lead to some problems. The first is the actual security of the data. Because it isn't controlled by one entity, the nodes that are storing the data can be located anywhere, which then can raise legislative problems. And if a problem occurs, then it's hard to actually account and be able to identify where it occurred. Not to mention having to cover the cost and operating management of the infrastructure. The next is artificial intelligence, more commonly referred to in this specific sector for machine learning, which is a popular technique that effectively allows for common repetitive tasks to be eliminated and to be made more efficient, which can assist staff in generating a range of different documents. So this can be for the opportunities, if you go to the next slide, for the opportunities can be to either assist in reviewing documents or to be able to automatically generate boilerplate documents that need to be repetitively completed, but don't necessarily need to be massively different for each different customer. And the artificial intelligence can also allow for voice dictation and natural language processing to assist with note taking, and for also potentially in courts and in the legal system to be able to make sure that details are recorded accurately. And that can also then be integrated with a chatbot and knowledge-based system to be able to generate meaningful results based on potentially fragmented information. So I think you've gone on to the challenges. Yep. So the challenges for AI is the cost of it is primarily at the minute. It's very expensive to develop, it's very expensive to maintain, and it's also quite difficult to train and make sure that you can get it accurate and reliable all the time. Not to mention, having any type of machine learning, there needs to be accountability. If something goes wrong, you need to be able to have confidence in the results that are being generated, or to be able to audit where that result is coming from. Which, if a computer is generating documents and something goes wrong, or it accidentally shares or puts in someone else's information, that can also lead to privacy concerns. And the integration of cloud into businesses, that's generally not restricted to legal. That's almost every single business sector nowadays. And instead of using on-premises infrastructure, you're using cloud resources. You're using other computers within data centers, which allows you to scale very quickly if you need demand, or if you need additional storage, or something goes wrong and you need to be able to quickly deploy something new. And it allows for you to be able to distribute your data across a whole load of different locations. But that can also then lead to concerns regarding privacy as well, a bit like artificial intelligence. So the opportunities that cloud can provide generally relates to backups and be able to, or an access of data. So you can load balance, you can deliver content to local networks, and to be able to audit details very, very closely. However, some of the challenges is the cost. Again, a bit like artificial intelligence, and the security, again, like artificial intelligence. And as we saw even a couple days ago, when Fastly went down, a cloud hosting provider, they did content delivery. Everything can go wrong. It can knock out entire websites and mean that they're inaccessible. So businesses that are attempting to integrate this, especially in the legal sector, need to make sure that there is some accountability, failover, some redundancy to make sure that this doesn't impact continued work. Cloud services are very, very powerful if used correctly, but there's also a lot of limitations. So the roadmap for the future, and where can we go? These technologies, artificial intelligence, cloud, and blockchain, have all been around for more than a decade now. They're all common, they're all known by the majority of people, even if it's just a buzzword. However, the implementation in the legal sector is quite difficult, mainly because of cost, security, legislation, and just implementation difficulties. And with the development and introduction of these technologies, it can be quickly outpaced. You can introduce something, and then next month it can be completely different, or can be completely revised to something that's better. So it will mean that for progressing into the future, we will have to take a closer, more rapid, advanced development cycle to be able to make sure that we can implement it and manage it securely, so that everything can work efficiently. And I'm not sure Taimoor is back. So handing over to Taimoor to enter the discussion phase.
Thank you, William. I'm back. Sorry, guys. I was kicked out by the technology. So let's really make it more reliable, at least for the legal services, if not for every one of us. Thank you very much, Vikalp and William, for a very good introduction. And it probably to those audience who are not familiar with legal tech. Just to continue the discussion, this is the second webinar of the series. We already had a couple of weeks ago, first seminar of this series. And that is also recorded and is available on our website if you are interested. Currently, in the current session, we will be mainly talking about the perspective of technology and law together. Since we have experts from both areas, the people coming from the law, tech, from law profession as well as from the computing background. So we want to ask our speakers to share their experience, what they have been developing in terms of technologies which can be adapted by the legal tech services, or what kind of challenges legal tech guys have been facing when it comes to adapting the modern technology. I'm sure there are a bunch of technologies around, but being most popular, as we have seen in the presentation, are really AI and blockchain based. So with this setting, uh, let me introduce our first speaker, who is expert in the mix of technology and law. She has been attorney at law as well as current head of artificial intelligence. Uh, Janet is with us. Janet, can you please tell us what legal tech is really to you and what kind of challenges you have been facing from the law perspective, being a law expert, or from the technology expert?
Thank you very much for the introduction. I'm very happy to join the discussions today. And given the legal and the tech background, as you already mentioned, the word legal tech embeds the question and the challenge itself, because you need a certain amount of legal experience and as well a certain amount of technological experience, kind of like to make legal tech work in the legal sector. So from my experience, for example, when we tried to implement a tool to automate document screening for huge due diligence processes, you need to implement those tools from a technology perspective, and then you need to train those tools for a certain amount of time so that the system can categorize corporate, employment, IT documents correctly. And this is a huge challenge to train these systems. And then, of course, you always have the oversight perspective, because as lawyers, we have a very high level standard of due diligence and diligence obligation towards our clients. So even though the legal tech does kind of like relieves us from a lot of looking through the documents, categorizing them, we still have this huge burden of responsibility and this control perspective where we need to go through everything a second time to make sure we don't miss anything, that nothing is misfiled or miscategorized, because we know technology is not perfect. There is always some room for, misunderstandings or correction. And this is kind of like one challenge. And the second challenge that was already mentioned is privacy and data control, because as attorneys, we are strictly kind of like we need to strictly adhere to confidentiality towards our clients. And there would be nothing worse than if kind of like these very confidential documents turning up in some leak, some public website containing all the information about the clients, transactions, and so on. So this is very difficult, in particular with cloud services. So the privacy aspect is key to, for example, legal tech being employed for attorneys in the judicial system and also in the legal in-house space. So these are some key challenges from my perspective I've dealt with from the AI and technology as well as the legal angle.
Right. Thank you very much, Janet, for sharing very wonderful experience. So since you mentioned different challenges, before we really look into these challenges, we have another expert with us, Maria. She is also coming from a diverse background of technology and law, but she is probably more inclined towards law. So let's ask her, what is really legal tech to you, Maria, and what kind of challenges have you faced, are you facing from the technology perspective or from the law perspective?
Okay, so let me first share a presentation that I used like 1 year ago when I proposed a group of people from Latin America. Let's discuss about what is really legal tech, because my feeling is that nobody really knows, and everything is legal tech and nothing is legal tech. So here are some ideas which just bring maybe more doubts to the room, but I think it's good to discuss, and that's why we are here. So let me share my presentation, which was here before, but of course is not anymore here. So one second. Yes, let me see. No, excuse me. Okay, let me share it, and I hope. Can you see it now? Am I sharing my presentation?
Yes, we can see.
Okay, great. So let's start here. So can you see number one? No? Okay, maybe not. 1 second. Okay, now? Can you see it now?
Yes. Yes.
Okay, let's go. So why I think this topic is relevant? I think that is relevant because, as the philosopher Ludwig Wittgenstein said many, many years ago, the limits of my language mean the limits of my world. And my feeling is that in the world at the moment, we don't really know what legal tech means. So we need to clarify that in order to speak the same language, to understand each other, and to create a discipline, which is something completely necessary at the moment. So this is called noseology, the meaning of words and the origin of the term and the limits of this word. So what is the origin of legal tech? I don't really know who was the first one that used this word. In fact, I looked for information I couldn't find. So maybe if somebody is in the history of law field, they could start researching. The thing is that, as it is obvious, is the mixture of two words, legal and technology. And then it comes legal tech. And it is an English term, but nowadays I can tell you that the whole Spanish world, the Chinese world probably, and all the world is using the same term to refer to this amount of things. Which amount of things? Well, as far as I see, many things. So on one hand, legal tech is a category of technologies. On the other hand, it's a discipline of knowledge. So we are here to talk about legal tech. But it is also some kind of companies like startups who are developing legal tech. And of course, it is all the above. Yeah. So at the moment, many things are legal tech. But does everyone use the same term to refer to all these three concepts? So if you talk about technology for law or technology that offers legal services, do everybody use the same term? Secondly, everybody use the same term for the discipline? So the answer is no. Besides legal tech, other terms are being used to call these things. So you also hear the word law tech. You also hear the word TMT, technology, media, and telecommunication. You hear the word computing law, computable law, startups, legal technology, tech for law, well, a mess. So consequently, different terms are used to refer to the same concept. One term can be applied to different concepts. And finally, some of the used terms are misleading and confusing. What are the terms I use? But this means it's not really that I use them, because I'm also not so perfect. In fact, I'm misusing them as well, because marketing is important to me as well. And for instance, if I want to position my company in legal tech, I need to use it in the way that everybody's using it. So I cannot use it in one way unless we arrive to consensus and we all decide to call things the same way. So far, because marketing is relevant to me and Google is deciding how my marketing should be, so I'm using the terms everybody is using. So a mixture and nothing very clear and technically not very good. So for me, ideally, legal tech should be software. That is what for me should be ideal. And software with a legal component. I will tell you more about my concept of legal tech. But I shouldn't refer to legal tech when I'm talking about the law of technology, discipline that studies the laws. For me, that is something different. That is in Spanish, Derecho de la Tecnología, or in English, Law of Technology, but not legal tech. Thirdly, the companies who are developing legal tech, maybe we should make a difference between the startups and maybe the companies, the big companies. But what I like saying is legal tech startup or legal tech company when they have over 3 years, so that's what I try to do. But I promise I don't always do it right. Then what is really legal tech then for me? For me is technology. What kind of technology? So technology that has a very high, let's say, critical legal component. What is a critical legal component? For me, that means what in marketing we call unique selling proposition. So let's say that what the customers are why the customers are buying this tool is because there is something legal very relevant in that tool. So on one hand, there we have technology that serves to provide a service of a legal nature, which could be public or private. Because for me, for instance, it is legal tech, the tool that the tax authority uses, as the tool that a law firm uses. For me, both are legal tech. And I think that very often people forget that the, let's say, most relevant legal tech that we have at the moment in many countries is the one that the state is using, that the governmental agencies are using. And not many people are studying them. I think there is an incredible field there. But then secondly, also tools that are helping legal professionals to do their job better. So for me, both types or all these types of tools are legal tech. Then we could classify them. And if I have to think about the different classifications of legal tech, I have to tell you that I have really analyzed deeply all these taxonomies that are already in the market. And myself, I have created one for my Comparador-Legal Tech, which is a tool, a platform where we have placed over 300 tools that are in Spanish. And it was so difficult to do that job. So now if I have to choose, probably the best way to categorize them is the B2B, the B2C, the B2G, the G2C, and the G2B. And further than that, I think we have to work very much into taxonomy. At the moment, it's also a chaos. For me, legal tech has to have something relevant in the DNA, and it is innovation. If it doesn't offer something new to the market, for me, it's not legal tech. Therefore, for me, it's not legal tech business projects without a technological component. And I see a lot of that. Every 2 weeks, I get an email or somebody in LinkedIn that says, "Hi, Maria, I want to introduce you to my superb legal tech project." And it is a website that says that they are legal tech, but that's it. You know, there is nothing of legal tech. It's just people who are trying to sell and know that you sell more if you are legal tech. So there is a lot of that. Then secondly, business projects with technology, but technology that doesn't have any like relevant legal component. That is also not legal tech, because it should be legal tech, not tech. Thirdly, technology without an innovative character, as I said, and all the above. That is not legal tech. And then one question which I ask you, because I still don't know how to do it, is should it be legal tech or it should be legal tech together? I don't know. I write it like together because I know that that is what Google likes, but I don't know. So that's a question that I leave there for the floor. So as a conclusion, for a better development of these disciplines, I think that we really have to have consensus on categorization and conceptualization. It is very necessary. The term legal tech is currently used in several ways, and we haven't decided yet how to use it. So I think that we should use the same term to refer to the same thing. I don't know if you like the way I define it, but we can discuss about it and open to better ideas, which I'm sure that there will be here. And yeah, let's talk about it. For me, is, as I said, high legal component. That is legal tech, and there should be technology and innovation in it. So thank you so much, and I leave the floor for the following.
Right. Thank you very much, Maria, for a very detailed introduction and a very exciting taxonomy, let's say, because I'm sure it will trigger many questions, but also probably some very thought-provoking ideas, particularly considering what will be probably a future legal tech. So as the next speaker, we also have another very unique expert with us. He is also an expert in the legal tech, but he has background in law as well. So he will be sharing his experience, particularly from the healthcare domain, because as we see, we are talking about different kind of legal services, legal tech companies which are providing different kind of technologies, but at the end they are really used in one of the application areas. And currently the most critical application area in which The technology is helping, and at the same time, it is arising the legal issues is healthcare. Everyone does not want to share their information, their data, and many things. And we have Evangelist with us, who is currently CTO in KK Legal. And he is particularly expert in digital healthcare legalization. So, Evangelist, what is really legal tech to you? And what kind of challenges you have been facing from the technology perspective and from the being a law expert?
Thank you, Taimoor. What is legal tech? This is a very good question. I would rather approach it in a different way. I would consider trying to categorize everything according to the usage of the technology and not the actual not the promises that technology makes. For example, we can use technology in the back office, or we can use it in the front office in providing services. These are two different things, and this is also very clear in the healthcare sector, because we have a very high level of regulation and strict data protection requirements. Technology has been used widely in healthcare and has been trying to, let's say, liaise with the traditional healthcare systems. My field of work mainly involves regulation and oversight of how these things are evolve. We have, let's say, let me rephrase it. We have radical changes in the availability of technology and the use of, particularly the use of data and record keeping, which has allowed a high level of patient services improvement. However, healthcare data is sensitive and must be treated with the utmost safeguards. Technology has not been particularly keen in providing these safeguards, especially for healthcare related data. With this in mind, most of the countries that have not been very eager to evolve have preferred to use technology for mundane and routine tasks and record keeping at the back office. My experience in Greece is that COVID provided a breakthrough, and actually it helped the digitization of the government. Until recently, we had a very hostile government towards to automation and let's say, and in the use of technology, even though everybody likes to say that they love technology, but when it came to government-related activities, for example, prescriptions, everybody preferred paper. Actually, until today, there used to be an obligation for the patient to actually sign the prescription, even though it was virtual. So we had huge discussions, and let me share this with you on moving into a paperless and fully digital prescription system. The main concern on that used to be the government accounting system, which did not allow for a virtual, which required the signing of the document and did not allow for a virtual signature. COVID forced the Greek government to move on, and everything suddenly relaxed. We have been trying for years to persuade people within the government system that moving into a more agile approach in how they maintain record and serve the citizens would be beneficial to all, and automating tasks. But it was only after COVID that the actual breakthrough came. Now, speaking as a lawyer, the point I would like to raise is that technology, when it comes to when it leaves the law office and goes into the provision of services, has a legitimacy issue. People actually need to understand the legal process in order to understand that it is fair and that the end result is something that they can trust. Otherwise, there will be a hostility towards to any automation. For example, even in mundane tasks, for example, smart contracts. If people cannot understand a smart contract, then they are more likely to challenge it. A judge will have a hard time understanding how the smart contract worked and actually making the calculations if there's a difference, let's say, in the way that the percentage on the transaction was calculated. In order to seek justice, to provide justice. So this is in my view, the main concern on any legal tech deployment, and this is why lawyers tend to be more conservative and prefer evolution rather than revolution. Technology revolutionized many of the things that we were working on in the past, especially the way that we have been doing our business in the law office. But when it comes to services provision, I believe that there is a huge gap, and it's not likely to be covered soon. Yes, we have replaced books with databases. Yes, for example, in my office, I have only one library. It must be something like 30 books. Everything is virtual. But this is something that refers to our work as lawyers. When it comes to serving the clients or even providing justice, serving justice, we still rely on the traditional functions, hearings. Even virtual hearings are something that's not desired by many. It was considered to be a necessity, and everybody's going back to the actual courtrooms. So technology is good up to a point, and we have to be careful in how we deploy in order to retain both the trust of both the people, but also our grasp on the issues. Finally, my last concern is security. We have been trying at our firm to implement an information security system, which we consider to be rather sophisticated. And we have found out that there is a difference between having strict security within the office and being able to work with our clients. For example, a document that is security categorized cannot be shared easily with an outside client, which means that we have to relax our security. When we strike this thin balance, this balance is very difficult to grasp, So we have seen that in many cases we have to do away with security just to be able to do our work. Legal tech provides us with many different innovations and ideas, but actually the thing is that this must be able to work and function to the benefit of both the lawyers and the clients. This is difficult.
Thank you very much, Evangelist. Yeah, you are very right, and you have brought some very critical issues which are certainly related to digitization of the services, and they are mainly related to security and the data privacy. But you also highlighted something very interesting, coming from the fact that uh, many organizations are really reluctant to adapt the technology because of several complications which they may face later. So this is really wonderful, and based on this fact that yes, it is really becoming more and more challenging, uh, we have another expert from a medical legal company. They are also providing some legal services to the actual patients when it comes to offer their rights, or when some dispute or conflict arises. Lal Akhtar is with us, and I will ask him that what kind of challenges you are facing when it comes to provide the medical legal services in your expertise, and how do you want to address them with the help of recent technology.
Thank you, Taimoor Khan. I hope you can all hear me very well.
Yes.
I run a company called Med Chambers. You can see my logo in my background. We are an expert witness agency. So what that means is we provide expert witnesses to lawyers and mainly solicitors in this country. Now, in a typical case, a solicitor, when they need an expert witness for a case, maybe a medical negligence or any other matter, they will contact us, send us an instruction that detailing what kind of report they need from what kind of doctor. And then we will match it with one of our experts on our panel. For example, it's a report related to a cancer specialist, for example. And then that doctor will look at the instruction, maybe examine patient as well, look at the medical records, and then produce a report, which we will then send it back to the lawyer. That report becomes part of the case file, and it ultimately ends up in front of a judge. Judge will ultimately look at the evidence, all kind of evidence, including the expert witness. Now, what are the challenges here? Challenges are about the security of the documents. Not security in terms of data protection security, which everyone knows. Security in terms of integrity of the documents. So starting from the first step, where a solicitor has sent us an instruction, a written instruction where they put our details, what kind of reports they want. Now, let's say a very clever, very smart secretary of doctor thinks that solicitor has not written what he should have written and decides to make changes to some of the paragraphs before passing that instruction on to doctor. Then we don't have that same instruction that we had received from the solicitors. Or once doctor has produced that report, it comes back and knowingly or unknowingly, some party decides to make some changes into that document. Now, that document is a legal document produced under Part 35 of CPR of this country's law. And it's very important that integrity of that document is maintained. And when judge looks at that evidence, this is exactly what the doctor or any other expert has produced. So in some cases, maybe, so we need to see, or from the judge's point of view, it's very important that there should be some kind of audit trail where we know that this document was produced and it is ended up on judge's table exactly in the format as it was. And okay, we can match it with other parties' document, or sometimes if the expert is there for an oral evidence as well, then they will see the document. However, if it is everything being done on paper and experts are not personally present in the court, then what is the guarantee that this document is 100% the same as what doctor has produced on their end? So there has to be some audit trail, there has to be some kind of security of that document to maintain integrity of that document. Different people use different methods for that. Some people will just rely that PDF document is not a Word document, so it will not be changed. Some people might think, no, PDF, there are something called PDF editors. They can change those documents as well. So they might put a password and make them password protected. And some people might use some kind of other encryption methods. But in this world, as we know, cracking a PDF password might take 10 seconds for me and maybe 5 seconds for everybody else. So we are looking at some different solutions, potentially based on blockchain, where we can have a full audit trail starting from instruction when it leaves solicitor's office, and then the documents produced by the experts, and then when they go back and end up back at solicitor's table, and then become part of the case file, and then reach to the judge's table at the time of the hearing of the case. So we are looking to maintain metadata of the documents, timestamps, when they were produced, how they were produced, what other documents were referenced in it. Let's say, for example, if there was any case history from your GP that became part of that document, or if there was any hospital records, or if there was any tests that were done and at NHS hospital somewhere, and they became part of that case. So all kind of metadata involved, all kind of reference documents, and also the contents of the report. That the contents are exactly as they started from doctor's computer and all the way until the solicitor's computer, and then in the case file. Obviously, we have lots of challenges in that. There are, again, data protection issues where the data will be stored, what kind of blockchain will be used. It can't be a public blockchain where anyone else can see it. It will have to be a private blockchain. Then within that private blockchain, how many chains will be used, whether it's one per customer, so keep every customer's data separate, or there are some kind of other checks where we can only show certain data to certain customers depending on their cases. And also, if GP surgeries can be linked when they send medical notes of any particular patient, if those notes are not tampered at any stage and reach to the doctor exactly in the form that they started from there. And also, again, security, that who is able to see those. So all these things, we're looking at different blockchain solutions. And hopefully, by use of this new technology, we will soon be able to make some solution on that. We're also looking at, so this was one of the potential practical implementation of technologies that my other colleagues today have discussed, have given overview or some introduction of those. But this is one of the practical things that we are looking at to utilize these technologies in a real world. We're also looking at AI for analytical purposes to make some prediction about the cases, and some kind of AI on producing expert witness reports, where we currently use some systems where we know they are not AI based, but they give you some kind of prediction while you are writing reports based on some of your selections. But we're looking to use AI to automate that as well, where it can help you produce the reports rather than you having to write everything from start to end. Thank you.
Thank you, Lal, for sharing your experience, which is again very valuable, because I understand not only the integrity of the information, but integrity of the documents, which are probably prepared in courts or at different places, which are part of non-digital world. And it's extremely challenging. We all are very well aware of it. But since so far, everyone has agreed that we are really looking for the data in order to use the technology. Some have highlighted very rightly the challenges in sharing the data because of several reasons. Considering all these challenges, someone among us is developing the technology which can help us to probably solve some of our issues one way or the other. We have our next expert, Lal Chandran, coming from the background in developing the technologies in Ericsson. He has started a new venture where he is not only developing the digital solutions, but he is also providing the legal services to commercial as well as the government sectors. And he has very exciting technology. Let's ask him, Chandran, what is really legal tech to you, starting from your experience, because you are really coming from technology background to the legal services, and what kind of services or technologies you have been developing so far, and what challenges do you really face?
Thank you, Dr. Taimoor. I'm hoping that you all can hear me very well. So my name is Lal Chandran. As Dr. Taimoor said, I'm the CTO and co-founder of iGrant.io, which is a personal data exchange platform that enables consented data exchange in a human-centric and auditable manner. We are a technology company that provides access to quality data from different sources in a legal, ethical, and sustainable manner, and we're headquartered in Sweden. So as Dr. Taimoor said, I come from a very much a product and engineering background over 23 years of my career. I've been very fortunate to be building new products my entire career, and my expertise include, apart from software development, security, primarily working very closely to regulations and the cloud. So before I go to the challenges itself, I just want to give a different angle about the concept of legal tech, or for that matter, when anyone attaches a say suffix like tech or a legal 2.0 or say law 4.0, whatever you want to call it, or when you actually add a prefix like smartphone, smart contract, smart that, smart health, and whatever, or an I into it to mean internet, or an E to mean e-wallet, to me, any discipline, any such usage of term means novelty. As Maria pointed out, innovation is a key. And when something, and when I say when something is novelty, we call it legal tech because we feel that it's a novelty and something that is not pervasive as yet. And I personally believe that any discipline, regardless of whether it's law or not, any discipline undergoes a natural process of evolution, or revolution, as Evangelos said, in adopting new tooling or automation that is prevalent at any given point of time. It is essentially in adopting a new tool or a new technology, quote unquote. So let's take law as an example. If you look at the history, and I'm coming from India, south of India, which is during my childhood, it has been very underdeveloped in many ways. So I've seen a world where law started with manual writing down. There were technical scripting writers whom we contacted and really started with the whole process. And then we saw typewriters being introduced. That was the technology then. Then we saw carbon copiers. We transitioned into advanced form like electronic typewriters where you could even store things. Then we saw computers, and then the rest is all history. I think we are all on board in the same game. So to me, it is an inevitable journey for any discipline or any sector to take, and law is not an exception. It is part of a digitalization that is being embraced across every sector, and it is here to stay and will continue to evolve or revolutionize. And it may have challenges, but historically, we as human beings has adapted to embrace anything that brings in certain advantages. And these advantages could be reducing human bias and errors. It could be reducing the perceived unfairness when it comes to the law. It could be increasing the speed of judgment and decision-making with the use of AI, for example. Or it can be in reducing the high costs. And that is where I conclude the primary challenges for me, without going into the technology itself, is two things. One is the governance. How do we build an adequate governance system, whether it is law, whether it's healthcare, whether it's medicine, so that people can trust and people can use it? Second thing I think is down, some of the things that have already been discussed, is down to willingness. It's actually the fear of adopting something new, fear of giving up something that you already have. That is the fundamental challenge, I believe, in adopting new things. And talking about the technology itself, and having worked in the security and data information sharing and exchange solution for many years, if not at least in the last 3 years, I feel the challenges are all down to, Lal Akhtar pointed out the integrity issues involved when you're exchanging data. How do you ensure the quality of the information that is being transferred from one point to other? How do we audit? How do we ensure that the entire system can be audited in an independent manner? So these are some of the technology challenges that I believe is fundamental, which is increasingly getting solved with new things that are coming in. So I think with that note, I will of course continue contributing. With that note, I will give it back to Dr. Taimoor.
Right. Thank you, Chandran, for very valuable experience. And since you are really building very exciting technology, not only to bring the infrastructures closer to the machines, but also convincing citizens to start using your technology. We also have another very diversified speaker. Since we are all talking about the digital transformation where everything is digital, we all have agreed that yes, there is a data, there are documents, there is other information which needs to be digitalized. We have Dania with us, and she has been working as an IP and IT law expert. And Dania, may I ask you to share your experience? What is really the challenges you have been facing when it comes to enforcing IT law and IP, particularly in the context of recent times?
So thank you all for being here. Thank you for inviting me. So I have been researching at intersection of law and technology for the last 4 years. To start off, I'm going to give you an example. Imagine you order some nice furniture online, and while it's being delivered, it gets damaged. So you contact the sender's customer service or the shipping service, and neither of them is being very helpful. So you decide to ask a lawyer to help you out. But here's a plot twist. You don't know any lawyers or what they are specialized in. Of course, you have options. You can Google some names or you can ask around. And sometimes there is a platform where lawyers can be matched with potential clients based on the exact expertise needed. So basically, it's like Uber, but you find a lawyer to help you enforce your consumer rights. So this could be one example of legal tech. And of course, there is more to the story, since legal tech can be used in many different contexts and for various purposes. We have talked today about legal tech in the context of a law firm, as well as other organizations for various matters, such as customer relationship management, for compliance, for automated customer support. Airlines are a great example here, especially with all the the money they had to pay back because of the COVID and the canceled flights. Think of cookie banners, for example, or tax software we used to submit our taxes every year. Services like these, which are often called regulatory tech or regulatory technology, they use a predefined set of legal requirements, and those requirements are then matched with technical development in order to create a user-friendly experience. Basically, tools like these allow a layperson to comply with the law. Some other tools can even apply legal rules to real or hypothetical situations without requiring human legal experts to get involved. So we're talking about computational law in this case. This means that the tool helps with legal calculations, for example, compliance audits or regulatory analysis, which are very important for big firms. And can also include things like online tax returns and privacy compliance software. Of course, one of the challenges is that when we say code or when we say law, we are normally thinking of quite different approaches. Let's use the example of a rule that says no vehicles in this park. So for us humans, it seems pretty logical. We know what a vehicle is when we see one, except it might be hard to say if a bicycle counts as a vehicle, or a skateboard, or maybe a repair cart. And this is a typical legal formulation. It is abstract and broadly formulated and uses undefined terminology such as vehicle. Computer code, on the other hand, gives tasks to the computer based on specific predefined steps and algorithms. And this means that the computer's idea of what a vehicle in the situation is may or may not correspond to the legal meaning. So to resolve these kinds of questions, some scholars at the intersection of law and technology are looking into how formal logic rules could be used in legal reasoning. So in other words, how to computerize the law. To do this, what has to be taken into account is the fact that judgment can be context and situation dependent, and legal reasoning is based on argumentation rather than deduction. And these two factors may not translate into code very easily. So some approaches to resolve differences are similar to work in the privacy by design community, which is where I have been quite active in the last years. We want interaction between the two fields to start the conversation and to bridge the gap in order that we can both learn from each other, see what the challenges are, and then hopefully propose some solutions to come closer together. A good example of such an approach is Comp Law Project at Stanford Law School. Their work is interdisciplinary, and the team is composed of both legal and technical experts. And what they do is they create technology that can be used by lay people to learn about the legal status of their actions, even though the legal system is vast and complex, and there are often overlapping rules. However, as they point out themselves, there is a caveat. So the system works the best in systems where, in legal systems, of course, where statutes are followed closely by the judiciary, with little room for judicial innovation. So this would effectively be civil law systems of continental Europe, where judicial discretion is limited, although it is becoming more and more popular in the US as well, especially with very detailed statutes, for example, in the privacy law or in tax law. So I mentioned this example of the vehicle. What we can currently say, based on the state of the art, is that currently applicable law can, to a certain extent, become computable. However, if the rule says no vehicles in the park, it is the easiest to computerize the law when the clear definition of a vehicle can be found in hard law. So when it is clear from the existing body of law what exactly is a vehicle. This is how the computer can also tell us if it agrees with us that it is a vehicle. So to conclude, legal technology holds many challenges, especially when we connect it to computation. And I'm sincerely curious to see what we find out in this panel. Thank you.
So thank you, Dania, for bringing us some other exciting areas and challenges, in particularly in the IT law enforcement. Since we have become familiar what kind of technologies are used and what kind of legal services are being deployed in order to use those technologies, I want to go back to the speakers, starting from Janet again, and asking uh, what is really way forward she is looking for in digital regulatory services. From her experience, whatever you have been providing so far, and considering the recent directives, particularly coming not only for the data part or the citizens part, like GDPR, but also coming to regulate the technology. I mean, particularly I'm referring to the recent AI regulation, which has been announced by European Commission. So what is really the way forward you are looking for?
Thank you for taking up the recent act of the European Union. So in April, the Commission put forward a proposal to regulate artificial intelligence. And basically, the Commission's approach is to regulate certain use cases based on the risk associated to them for the rights of and freedoms of the citizens. So there are 4 categories. The first category would be the prohibited use of artificial intelligence, for example, for biometric mass surveillance on public places. And here there are exemptions which are to be implemented by the member states for law enforcement purposes. So this is something that is very much discussed and highly critical, because the exemptions here for law enforcement purposes are not quite that defined to point, because kind of like in urgent matters, or kind of like in case there is severe danger, provides a lot of room for maneuver for interpretation. So this is something that will be discussed very intensively. And also with kind of like a view merging law, judicial law enforcement, and the biometric mass surveillance based on AI. A second point I would like to make is the high risk category. So certain use cases of artificial intelligence are defined as high risk. Here, kind of like this is a majority of fields, and some of them relate to law enforcement. So kind of like also using AI in the field of law enforcement, of migration control, of border control is considered high risk. So there is awareness that kind of like, employing technology here is related to a higher level of risk for the freedoms and for the rights of people, but nevertheless, it shall be kind of like you can deploy such technologies. And also here, there will be some discussion because, for example, the use of AI when validating evidence, or validating kind of like what people say in court, or predicting if certain people are more likely to commit crimes than other people, or kind of like other categories of people based on the parameters you feed into the system. And here we need to be very, very aware and conscious of kind of like what parameters are put into the system, which data are we using, because I think we all know that kind of like the system is the one thing, but it depends on the data that you put in that will be kind of like very, very highly reflected in the outcome. And of course, also we need to be aware of bias and the shortcoming of such technologies, because the technologies work better on kind of like the field they are trained on. And we very well know that in particular with recognition software, kind of like there are geographical differences. So going forward, we will need to be very careful and look very much to those systems. I mean, the EU plans for these high-risk systems that they are or need to undergo certain compliance restrictions. So the system will need to be documented. There will be a certain level of robustness and cybersecurity required. There will need to be some quality control, and you also need to kind of like do some post monitoring of these systems. So kind of like once they are put into action with a CE conformity declaration, which is maximum valid for 5 years, you still need to monitor the system. And what is very interesting is that the AI Act also enforces obligations on the users, because the one thing is the systems provider that of course needs to make sure his system is compliant before he puts it on the market. And the other dimension is of course the user dimension, which would be, for example, governments using AI systems in judicial law enforcement, or other corporations, for example, using such AI systems in their organizations. And users, of course, also need to be kind of like very careful. And here the Act provides for human oversight, which I personally think is very important, in particular in the high-risk systems category, where you are so close to touching upon rights of other people's. And you need to kind of like operate the system as per the instructions of the system provider, because everyone knows if you do not use the system as it's intended, of course there is a high potential that kind of like the outcome will not be the one desired or the one that the system is designed for. And in case there is malfunction or outage or something like that, there of course will also be the obligation, or it's intended that you need to kind of like stop using the system, report back to the provider, and resolve this. So particularly for the field of AI in the judicial field, so in law enforcement and these high risk categories, there will be a lot of movement in the next years due to this AI Act. And of course, it's not quite finished and there are deliberations going on. And we will see where we land, in particular on the mass surveillance in public places and the exemptions for law enforcement purposes, and also with the high risk categories, which are also being heavily debated in some points.
Thank you very much, Janet, for sharing your thoughts. Certainly, these new directives are making things more formal when it comes to assure compliance of different digital services, I would say, like any other service. Legal tech is certainly one of them. But we also have other diversified speakers coming from the actual background. And as Maria is one of the key expert coming from both the worlds, let's ask her, what are your thoughts? What is really the way forward you are looking for when it comes to enforcing recent directives to legal tech services?
Okay, I have organized, let's say, what I'm going to say in three, basically in 3 pillars, which are, I think, the 3 pillars, the basic pillars of digital transformation, as you probably know: people, processes, and technology. They say platforms, the 3 Ps. So what I'm seeing in general is that people is the key thing. So if we want legal tech to be successful, if we want digital transformation to be a reality in this sector, the first thing we have to do is work on people. So what are the problems that I'm constantly facing with people? Well, the big law firms, they are too busy and they're making tons of money. Crises are not affecting them, as it is not in general affecting the legal sector, because you know that we are quite anti-cycle. I think that's the word in English, no? We are, when it's crisis, we go to court or we help people with bankruptcy. When there is no crisis, we help with M&A or creating companies. So there's always business for us. So there is not really a need to jump into technology. Besides, technology is something really far away from what we lawyers are used to. We like books. You can see my background here. So, you know, like this digit 0 and 1 is something like we really have a kind of a scare. So, okay, you're asking me to get into a business that I don't understand a thing? No, you know, I have my computer guys. What about computer guys? You know, computer guys are in paradise when they are happily hired by a law firm, because they are the kings in the, we say in Spanish, I don't know if in English you have the same expression, they are the, how do you say, somebody without an eye in a wall of blind people, you know, that's a said in Spanish, you know. they only see with an eye, but what means that is that nobody knows anything about computer science, and nobody wants to know, which is worse. Well, sometimes there is like some weird, freaky lawyer, but that's like sometimes. It doesn't happen very often. In those cases, okay, maybe the freaky lawyer starts sitting very close to the the computer science guy, and then things happen. But in general, no interest. So I always say that there are these kingdoms of computer science or computer experts in law firms. And what do lawyers do? Exactly what these computer science guys say. But computer science, you are great, and I love you because you can do fantastic things for us. But of course, you are sometimes lazy and sometimes happy in your, status quo. So very often, there is this horrible thing called the cloud. And there's this incredible framework called data protection, and if you mix data protection with cloud, wow, risk. And lawyers, we don't like risk. So, software changing things, we're making money. So I'm telling you what happened with people. So the big thing, the first thing we have to do is try to convince these people that this is not, there is no choice here, and that this is not something of the computer science people. This is something of the market. This is something of the clients. And this is the funny thing. What is happening now in the market is that clients are much more ahead than the law firms themselves. I tell you that most companies here, because of the pressure of the computer guys of the big companies here, they are forced to do digital transformation. So they are going to the legal department, to the in-houses, and they are saying like, hey guys, everybody in this organization is using computers for everything. We have traceability for everything. Everybody's using KPIs. Where are yours? Because we want to save money and we want to control your work and we want to know what you're doing. So that is happening here. So now every in-house is trying to do that. And the law firms are saying like, okay, the big ones, we know our work is unique. We cannot go into this computable thing because we are unique and we are superb and we are different. And we only do complex things. So, our life is not computable. Let's leave this for others. Okay, but there are the big fours, the KPMG, the Pricewaterhouse, and they are putting tons of money and they are creating acceleration programs and they are there. So let's see what happens in the coming years. I think that those big law firms and medium-sized law firms which have the capacity to become very, very computerized, they will jump in, but maybe it's too late for them. Maybe these big four have already done it and there is like no path. And I tell you this because like today I got a phone call from the biggest law firm in Peru, Chile, Colombia, and whatever, and they are talking and looking for somebody to advise them, but it's now. I'm already working in this field since the year 2012, and I was not the only one to start that, So to me, it's amazing that these leading companies are not understanding what is happening. And this reminds me to what happened to newspapers, Already several years ago, I knew that they were going to die, and I'm not so brilliant and just common sense, And they waited and waited, and then suddenly, oh my God, there are all these digital newspapers, and now there is no space for us. And now we have to give everything for free, and we don't sell paper newspapers, So exactly the same. So second thing, and let me go a little bit fast and let's finish, processes. Big problem as well, because law firms, they don't really think about processes, they just do things, and they're in a group of individuals. Normally, in the UK, you have these big, huge law firms with a lot of staff, but that's not the case in my country. There are only like 50 big law firms which have some kind of staff people. In general, it's like solo lawyers, 1, 2, 3 people. Do you think that they know their processes? No, they just do them. So they don't know the processes, so they don't know where the pain points are, they don't know where to improve the processes. So, well, analyzing processes is a big point, where and if you don't know the processes, of course, you cannot put technology for the processes. So that's, let's say, the second big point where I think we have to act. And then finally, technology. And the funny thing is that a lot of people are just looking at technology because it's like, okay, I have to buy technology because everybody's talking about legal tech. So they don't look at people, they don't look at processes, no, they just jump into buying technology. So then there are like, sometimes there are these very good sellers, and they come here and they say like, nothing more complex than this law firm has bought this software. And then they immediately say, oh, they have it, I have to have it. So they buy it as well, without really needing it, without really not understanding that if you want to have a competitive advantage, maybe that's not the software you have to buy. Maybe you have to develop yourself a software, or maybe you have to buy another one from a competitor, but not the same one the others are buying. But here, there is a lot of copy and paste in buying legal tech. So not much thinking, just if they do it, I do it. So I don't want to say the name, but there is an AI solution from the UK, which came here with a couple of good sellers, and all the big law firms bought it. And it was completely frustrating because it was not adapted to the market. And that's one thing that is very important about technology. Technology has to speak the language of the country. And that means the language that we speak, but also the legal language. And that's also a big handicap for software. And I think that's one of the big problems for legal tech. And it is that in many, many cases, legal tech is national. It cannot become international because it's based on the legal systems. And I could go on and on because there are many other problems, but I think I have to leave the room to somebody else, so we can go on if you want at the end. Sorry if I spoke for too long.
No, that's fine. Thank you, Maria, for sharing your thoughts. Evangelist, coming from a very critical application domain, healthcare, what are your thoughts to move forward with the recent directives, not only from the technological enforcement, but also from the legal perspective?
I would like to carry on the points that Maria made and answer your question, Taimoor. Are law firms gonna die if they do not adopt technology? The point that Maria made, and sorry about that, but I'm eager to answer that because it was something that has been in my mind for years. Maria, I'm not very sure because law firms have a huge profit margins, which means that they have a lot of space for cost-consuming mundane tasks. Of course, they will be less profitable, but unlikely to die. And this is why I think they have not been so eager to automate repeated processes and actually cut costs. This is something that we have to consider because investing in technology, and this is me speaking as a managing partner, is something that most of us like, and we expect that it will reap profits in the future, but rarely does so. Rarely, sorry, it comes with a slower pace than we anticipate. So this is something that is a very good point. And also, I would also like to point that Maria was actually very on the point on the localization issue, because coming from Greece, we are, let's say, 12 million people speaking the language, not a big market. We have huge problems in machine learning. There is not enough data that can help machine learning. So there are actually very few applications that can be customized in the Greek language, let alone the Greek legal system, which is another threshold. So sorry, Taimoor, because it was something that when Maria made her points, I was being very, very close to that, and I would like to also share my understanding of it, because it's something that we have been facing. For example, we do not even have a decent contract reviewer software in Greece. The processing, the Greek processing automation software, automated software is very basic when compared to the add-ons existing in for English or even Spanish. So I think these are the main problems in adopting legal tech, and this will become worse, and probably the gap between the richer, let's say, jurisdictions and the poorer ones will widen when it comes to artificial intelligence, and meaning that countries that are based in English or maybe Spanish will have a huge advantage over the other jurisdictions where they will be able to use AI tools and be a lot more effective. Finally, my last input, because she was very provocative, is that the big four are actually invading law, and I'm not sure if this is something that should be allowed. If you remember, after the Enron scandal, the big four were split, and the legal parts were removed from them. Now we see emerging, and actually they are heavily investing in artificial intelligence because they can. They have the resources, and they will have huge cost-cutting effects. Most of the other the firms, the law firms, and I'm talking now local law firms, not global law firms, do not have the resources to do that. It's a heavy investment, and one that will not reap profit soon. It's also a very risky investment because you have to take a gamble on the technology that you choose, and not all of the technologies will actually pay off. These were my concerns on Maria, so I think that I wanted to add on that.
Oh, thank you, Evangelist. I understand your point. So we also have Lal Majid, who is also working in the medical legalization, or particularly developing the witnesses, as he mentions and as he calls. Lal, what are your thoughts about new technologies, and how do you see it as a way forward for your company or your services?
Well, I will continue from what Maria and Evangelos discussed. After interaction with a number of law firms, I work with around 2,500 law firms in the UK, providing them expert witness services. In law firm, technology adoption is same as any other sectors. It comes from two sides. One, from cost saving point of view. If the new technology is going to save you any money, is it going to put money in your pocket more than it will take out of your pocket? And the second thing is, are there any other external factors, for example, your customers force you that you need to be on a certain standard before we can do business with you? Now, looking at first factor from cost saving point of view, with UK law firms, there are a number of things where they can potentially save costs using latest technologies. And that's why, starting from the bigger firms with deeper pockets, investing on technology, and then rolling it to the next level firms as well. I'll give you one practical example of where AI can help law firms save some money. For example, you're one of solicitor, one of the lawyer is working on a case where there are 10,000 pages documents containing different witness statements, different other case-related materials, and now one of the days that lawyer decides to get up and go and work for another company. And you have got another lawyer to take over that case. So will you expect that new lawyer to read through those 10,000 pages once again and spend another, let's say, month or whatever billable hours? And would you expect to charge your client for that many number of hours just because one staff has moved and a new staff is having to take over? Or do you expect your company to absorb that that many hours of work? So, but if you have AI and maybe potentially you have a very nice summaries of all the documents, where a new person can just read through the summaries rather than having to go through every single page of 10,000 pages and bring them up to speed to some extent, it will potentially save you money. Or you are managing a team of 10 solicitors, 10 lawyers, and are you expected to read every single email, every single document that is sent to any member of your team, so you know where those people are and you can potentially guide them if they are making any mistake? Or would you prefer that every document that is produced by your team members that is 1,000 pages length, you get a 5-page summary which potentially includes every single important point that you should be aware of as a manager of that team, and maybe a person on a partner level who is one level above you might get 1-page summary of every 1,000 pages document to know what's going on in his or her department. So those kind of things are AI driven, and lots of firms I know are working on that kind of things. That's a cost saving type of scenarios where solutions are being brought in to save cost. Other side is where your clients force you. So let's say you must have come across scenarios where a company will come and say, are you ISO certified for security, for example, 27001? Are you customer service and all other 9001 type of certifications do you have? Because we only work with solicitors or lawyers whose companies are certified with certain ISO certifications. Similarly, there might be a time when companies will come and say, you as a lawyer are using certain tools, for example, blockchain to secure your documents, because we need a certain level of audit trail for any document that is produced related to our case. Because if we ask you at a certain point that have you written this contract or have you written this witness statement, and you say, oh yes, it was produced, and then we say we never saw it, and we want to see metadata to see it was actually produced at that time, but maybe you can just go and manipulate metadata. So we need some kind of tools like blockchain where there's a timestamp of every step, where we need to know it was actually produced when it is when you are saying it was produced, and then what stages it went through, and also if there is a certain process in our agreement where it says document will be produced by a junior solicitor, it will go to a senior for review, it will go to a third level for review, but you actually just rely on the document that's produced by junior, and it's never been reviewed. So can you see the steps embedded in the document using technologies, for example, blockchain? So this kind of things will be driven from the customers. They will force you as a lawyer to adopt these technologies, so that and they will only work with companies who use those technologies.
Thank you. Thank you, Lal, for sharing your thoughts on the recent directives. Since we have Hovi with us, just to give you the context, Hovi, so far we have been talking about the recent developments in technology, particularly AI and blockchain and its application to different legal services, where different experts in the panel have been developing. Looking at the academic side of the world, since you are expert in developing the technologies and your recent experience in the context of various DARPA projects, particularly developing cognitive AI technologies, can you share your recent developments in this area and how do you see their application in digital services in general and legal tech services in particular?
Yeah, sorry for the technical difficulties, but I'm here now. I was involved in another panel discussion a couple of days ago in which my organization, the Computer Science and Artificial Intelligence Lab, every year has an annual meeting with all the companies that are part of our affiliates program. And the panel was on cognitive AI. And I introduced it by saying this is more about challenges than accomplishments. And I think that plays into this. Just to give some historical setting, you know, AI is still a relatively young science. It was brand new pretty much when I first got involved in the early 70s. And we've gone through several waves. You know, some of those waves have been very early on attempts to mimic human neural processing, which has made a comeback recently, of course. And then a period of much more symbolic and reasoning-oriented AI, some of which was phenomenally successful. You know, we built systems that could be very good at diagnosis, that could be very good at planning. In fact, we have planning systems today that are superhuman in their performance levels. The problem with all of these systems was that, generally speaking, to get them to work well, they needed to work in very narrow domains. And that was why the expert system revolution took over for a period of time. It turned out it was much easier to build the system that had the expertise in some very limited domain than it was to build the system that had the common sense of an average person or even of a 2-year-old. And because of this, these systems were incredibly brittle. Let me give an example. There was a very good medical diagnosis system called the Present Illness, which in the middle of interviewing a man about his symptoms, asked, "Are you pregnant?" And, you know, clearly a faux pas and wrong, but the system didn't understand that only women get pregnant. There were many other things like that. I remember another instance where it came out and asked somebody if they'd been exposed to rabbits recently. And the answer actually was yes, but it was completely surprising because there's some diseases that are transmitted through rabbits. So these programs had this issue of having a surprising set of knowledge, often better than human level of performance, but very narrow and very brittle. And there were a number of forays into legal reasoning. The reason I raise this is that this brittleness and narrowness and lack of common sense is a serious concern when dealing with human affairs. Because these systems were all hand constructed, because we had to build the knowledge into them, there was a counter wave that said, couldn't we have these machines learn on their own? And over the last decade or so, technology has emerged, you know, deep learning and its related technologies that have done exceedingly well on that problem. But primarily what they're building systems are not systems that understand, but the systems that can recognize something. And this could be enormously useful. For example, one of my colleagues was involved in developing a program that could read the radiological images from mammograms and do better than oncologists, or except the very most expert, at diagnosing what those images told you. So I'm not trying to say this technology is not good. It's very useful. But notice that that program has exactly the same weakness that the expert systems did. Namely, it's exceedingly good, superhuman level performance at an exceedingly narrow task. Now, I just wanted to show, I can share my screen quite briefly. I just wanted to show an example of something, and that's not the one. Here. Is that large enough for people to see?
Yes.
Okay, I can full screen it also. Just before I became a graduate student, one of my predecessors, Eugene Charniak, built a system that was intended to try to understand children's stories. And this is an example from one of those stories. Janet and Penny were going to the store to get presents for Jack. Janet said, "I'll buy Jack a top." "Don't get Jack a top," says Penny. "He has a top. He will." And now the reason this is left to be filled in is this very same example was given to a modern system, which is sort of the best system of the statistical machine learning type that deals with natural language. There's a system called GPT-3. Many of you have heard of it. GPT-3 can generate exceedingly human-like natural language. And one of the tasks it can do is to complete a story like this. So you might wonder what GPT-3 did. And the answer is it completed the story by saying, "He will get a top." "I will get Jack a top," said Janet. Now, that's a ridiculous answer. And what it's illustrating is that although GPT-3 is very good at stringing together words in English that seem to make sense, it doesn't actually know what it's doing. Because the whole point of this story was that you shouldn't get Jack a top, and we know why, because he already has one and wouldn't appreciate it. And I'm raising this to illustrate the potential pitfalls of systems that interact with people that lack deep understanding. And that's still a big challenge. Building systems with human common sense is exceedingly difficult. Now, there are many areas where that lack of common sense doesn't much matter. If I want to build a system that can diagnose potential metal fatigue failures in a jet engine, I don't have to know all of the things about the real world that a human would normally know. But when I'm dealing with medicine or the law in particular, we're talking about human affairs and their interactions. I just want to give a couple of quick vignettes. These are stories. I'm working right now on a potential project on cross-cultural understanding. And I think these two stories are very illustrative of the kinds of problems that arise when you interact with people. So the first story, this is a true story. I had an Uncle Sam who had spent many years in the Philippines as a factory manager. And when he moved back after, I think maybe a decade there, he went to a store in the United States, the Brook Brothers, high-end men's clothing store, to buy a new suit. And he tried on a suit, very nice suit that he liked a lot. And he turned to the salesman and said, "Oh, what does it cost?" And when the salesman told him the price, he turned to him and said, "Is that the best you can do?" Now, that was behavior that in the Philippines was not only sensible, but required, because it's a haggling culture. But in the United States, it's offensive. Of course, if he was buying a car in the United States, it would be appropriate. And notice everything that's going on in there, the tone of voice, the affect, his body posture, the fact that he wasn't actually mad, although he's expressing anger. All of these things are parts of the complications of human interactions that are very close to the things that go on in legal practice, which is why I'm raising them. The other example I wanted to give, which is slightly different, this is from a Harvard Business Review article on negotiating. So there's a huge technical literature on negotiating cross-culture. And this one is from an American, it's about an American senior VP, I think, at a company that was trying to negotiate a deal in China with the deputy minister of some ministry, I think Ministry of Education. So, you know, his underlings had been over there for a long time. They had been engaged in various meetings, a lot of parties. When he came over, as advised by his interlocutor, he went to a party the previous night. They drank a lot. They didn't discuss business. The next morning, he went in for the meeting with the minister and said, "So can we now move on to, you know, closing the deal?" And the minister said to him, "You know, you just got here. It's a long trip. You must be very tired. Why don't you take some time and enjoy our beautiful city?" And so, because he had an expert advising him on how to interact in China, he went and toured the city for a week. I actually don't know where it was. It was probably Beijing. And then they got into the negotiations, and I believe it was successfully consummated. Now, the interesting thing to note in this case versus the other one, in the other case, the two parties had the same goal. They wanted to get the suit sold to my uncle. In this case, they actually had different goals. So the American, VP's goal was to close the deal. It was very transactional. The Chinese minister's goal was to build a lasting relationship of trust. And although I doubt that he actually cared that this guy was tired, it was a way of saying to him, that isn't the way we do business here. We build relationships, we don't do transactions. And so, although I think he was probably annoyed, he would not express it, it's inappropriate in their culture. So notice what's going on here, that, the presentation of affect is often giving you wrong indications. In one case, the guy's being very solicitous when he's probably mad. And in the other case, the guy's feigning anger when he probably isn't angry at all. So understanding human interactions, which is past the edge of what we can do in AI today, is a very, very complicated business. And it's a business that happens at various different levels of interaction. Some of those are at the level of goals and plans and tactics. Some of those are in how we choose our language, what language we choose. And some of those are at how we express or don't express emotions in terms of tone of voice, body posture, and so on. And, to be a successful system that can really interact with people as naturally as people do, we have to solve the problem of doing all of those things. Now, I don't think we need to solve all of those things in order to help in legal systems, but some of these raise pitfalls in terms of, if you're involved in a negotiation that involves the law, which often happens, exactly what are people conveying and what are relying on our systems to do. If we're relying on them to be clerical, that's probably fine. We can build good clerical systems. If we're relying on them to understand the law, that's more complicated, because the law is already an expression of human values and interactions. And if we're relying on them to understand the law in a particular situation, they have to understand that human interaction that the law is trying to be applied to. And we are some of the way to being able to do that well, but it's still a huge challenge. We can do things like retrieving precedents. So given a story, some description of what happened, can we retrieve legal precedents that are possible matches to that? And I think, to some degree, we can do that reasonably well. One of my colleagues who passed away a couple of years ago, Pat Winston, he was building a system that was very much involved in using stories as precedents to understand other stories. And this is very similar to legal case-based reasoning. I should mention that there's been a whole, there was, again, in the period of more symbolic AI, there was a whole wave of case-based reasoning, which seemed to have faded out more because it was successful than because it didn't work. So there is some hope here, but I also wanted to raise the caveats.
Okay, thank you very much, Ovi. And this certainly makes sense, but you have identified the right shortcoming of the technology, and probably you have identified the right use, in fact, to build clerical systems. And this is very much helpful. And based on our discussions, we have somehow already identified the challenges which certify this conclusion. So since we are getting closer to the end of the event, probably 13 minutes away, let me ask you another question, which is also kind of thematic. Considering the developments in the technology and all these directives coming up on the other end, I'm sure you are following the news. European Commission has recently introduced AI regulations where they want to make AI systems more trustable. What kind of changes do you expect in curriculum which should be addressed in order to bring these two worlds together, the technical developments and probably, I mean, whatever you call it, whether human perception, human understanding of the problem, or these kind of regulations?
Yeah. So I think the key thing is whatever we rely on systems to do, they need to be explainable. And by explainable is a very difficult word because, you know, a system could say, I did this, I did that, I did the other thing, that's the answer. That may not be the sense of explainable that we really mean. We want the system to be able to justify its conclusions in ways where we can at least evaluate whether that makes sense or not. So, you know, in a much more advanced use past the clerical level that we could imagine is a system that you ran a legal argument by, and it might critique it. Now, it's in a semi-autonomous mode, right? You'd ask it, you know, critique this thing, and it gives you critique. If the critique's nonsense, you can just ignore it. But if the critique is useful, if you find some flaw in your reasoning, or if it doesn't, that's useful information. So that's the second thing, besides explainable in the sense of being justifiable and open to auditing and all the things that go along with that. There's the sense that using it in a semi-autonomous mode, one in which it works as a partner rather than as an autonomous agent, I think is the second thing I would, you know, be very much in favor of. Often this notion of justifiable is actually made by analogy to the law, which is, you know, if this system were to be liable for something, what would it need to be able to do to justify itself in that liability context? So I think that's a pretty reasonable way of thinking about a system that we put into critical decision-making roles, even critical advisory-making roles.
So towards the end, what kind of challenges do you see, Hovi, when it comes to applying even the existing technology, particularly in the legal tech services? You mentioned some of them, but with the recent development of legal services, which are at least using AI in a clerical way, let me say that way, what really challenges at the technical level do you see at the moment, which they need to address, probably at least to adapt the current technology in the best form? Let's say that.
Yeah. So, you know, one thing that's sort of obvious is law is written in language, you know, in natural language. And, you know, natural language has ambiguities. It often leaves a lot for you to fill in. And all of these things that we as people do quite easily. But in understanding what a law is meant to imply, you know, first of all, even just making, you know, syntactic sense of natural language is quite difficult. We have systems that are reasonably good at it, but none that are great. Yeah, one of my colleagues has a very good system called START, but, you know, I can easily construct sentences that it can't make sense of, that are perfectly understandable to a person. And that's not even going to the next level of understanding, which is, you know, what are the missing things that weren't said that are assumed you would be able to fill in? Just as in that children's story, you know, more is not said than is said. And so I think that, you know, those are real concerns about how far we can go until the technology in those areas gets better. Again, you know, to me, probably the most important thing is the things be explainable. You know, and that's a big weakness. You know, I don't think in legal cases very often the perceptual level AI technology that's being used today is, it's not likely to be the most commonly used things. But deep learning techniques and similar things have been, you know, they've been expanding the range of things they can do. And I think it's very important to understand the bounds on all of these systems, you know, capabilities when you're using them. That's probably the biggest advice. That was a question that in this other panel where, you know, somebody asked us that question, were we saying people shouldn't be using AI technology? And, you know, the answer was quite the opposite. We think a lot of it's quite good, but every one of these systems is limited and brittle. to some degree. And so you have to understand where those limitations are, what you can rely on them for and what you can't. And that varies from system to system.
Right. Yeah, that's very deep insight, and I perfectly understand your concern. And it is evident, by the way, by the recent developments, which particularly one of the leading projects which you have in US, Explainable AI, and all others, they have yet not produced something very significant, which at least has got some attention. I mean, either in academics or in industry. That's very helpful. So towards the end of the discussion, I would say that if any other expert or speaker wants to share their thoughts about whatever we have concluded, we understand that everyone has their own opinion, but at the same time, we have learned at some limitations of the technology. Certainly, there is one way or the other to use them in a way, but we understanding the fact that technologies have some limitation, it probably makes much easier to understand what kind of system we can really develop. And from the law perspective, as Hovi highlighted, very critical point that it's written in a natural language, which is exactly at the probably level of human cognition. I doubt when we will really be able to have a technology which can exactly express the same spirit. Yeah. But other than that, if you have any other thoughts to share towards the end, any concluding remarks before we move to the questions from audience.
I just wanted to quickly follow up on the curriculum that we briefly raised. So education and its role in bridging the gap between legal and tech. So it's something that's actually happening at law schools. I work in Belgium, so I know the situation here the best. There are basic technology or scientific courses that are made available to the law students in order to make sure that, you know, typically we go to study law because we don't like dealing with numbers, right? We're all scared of mathematics. In this way, it's a very gentle introduction to topics that we would normally be maybe hesitant to approach. For example, where I'm doing my PhD at the University of Brussels, there is a course called A Gentle Introduction to R for people who are afraid of R. On the other hand, there are also legal or ethical subjects that are being taught at engineering schools. With a focus on, for example, big data and privacy or ethical impact assessments. There are also, shall we call them, hybrid books of law and technology. For example, Mireille Hildebrand's book, I forgot the exact title, but something in the sense of the law for normal people, something along these lines. And I think that is extremely helpful in enabling the future generations of lawyers to be able to find our way through this all the time changing world of technology.
Yeah, thank you, Natalie. Certainly, being a doctoral student, you have more insight what's going on. But yes, that's very valuable to know that there are some courses which are already addressing the issues partially. I mean, we don't want to know the exact level of information, but still at least there is a move in which people have started thinking about introducing these side effects, let me call the side effects of the technology. So with this, there is some question appearing in the chat window. So someone has raised the hand.
Yeah, this is me.
Yeah, please.
Yeah, yeah. I wanted to say something about what Howard mentioned about natural language and if a solicitor's language is understandable to a computer. Yes, there are many ways to say the same thing, especially if you have to give a different impact to your statement. So, for example, if you want to say the same thing but make it a little bit softened for a judge or the other party, or you want to make something of very impactful to make other people realize the gravity of the situation. You can say same thing in many ways. So that's why when you are presenting an argument to a judge, or when you are writing a witness statement of somebody, it will be very hard for a computer to understand the full context of a natural language and make sense of it. However, in terms of technical documents, for example, an expert witness, they don't have to write their reports in any certain way to favor any party. So there we can standardize it. And we have already standardized simple reports, for example, GP reports for cases related to soft tissue injuries like whiplashes. So there you can only say, you can say in many ways, but if we give you a limited option to write certain things, then they will be easier for machines to understand. So for example, you say, if it was a road traffic accident, your car was hit from behind, or your car was hit from side, or you are a passenger in a passenger seat. So rather than giving them option to write this in their own way in 100 different ways, you just give a standard option to them. And that will be easily understandable for computer.
Right. Yeah, that certainly helps. But as Hovi mentioned, it's difficult to at least infer these kind of choices to the machine system. Right, Hovi, or do you have any comment?
Well, I think this is an example of the right style of thinking, which is, understand the limitations of the technology you're trying to employ, and then structure the context so that the system can do well within that. So, the idea of using restricted language so that you can actually do natural language level things, but in a restricted language, that's been used quite a bit and quite successfully. There was a language translation system that was done many years ago that was translating technical manuals. And the thing that made it work was that this manual, the people who wrote the original versions of the manuals in English, I think, were constrained in terms of the syntax and vocabulary they were allowed to use. So English is a particularly horrible language, as everyone knows, because it has, a huge vocabulary, lots of word senses for each word, and also quite complicated syntax without many syntactic markers. This is not a highly inflected language, but you can constrain that and still allow people to be expressive, and then make something that's actually translatable into a lot of other languages using the existing technology. So I think that kind of compromise of figuring out what a system is capable of, and then seeing whether you can structure the use case so that its capabilities are not outside its bounds.
Right. Yeah, that's actually a very good understanding of the context. Yes, that certainly helps. So with this, we are already toward the end of the event, and we are running 1 minute late. So with this, I would like to thank you all, not only the panelists, but also to attendees. Thank you very much for sharing your very invaluable thoughts and your very exciting experience. Just towards the end, we have another announcement. We are going to have a legal hackathon from 9th to 11th of July. And that's a very interesting event because we are going to talk about digi rights. Maria, do you want to introduce some details of the event? Maria is not with us.
Yes, I am.
All right.
So,
okay. Yeah, please.
Thank you, Taimoor. I'm very glad to announce, and I have left the link to the website where you can check all the data, practical data, and you can register if you decide to join. We are looking for pioneers, people who are curious and want to enjoy one weekend with others trying to develop tools to empower citizens in the knowledge of their rights, digital rights. That's why we have this name of Digi Rights, and also on how to make their rights effective, more effective. So if you want to be with us, it will start in the afternoon of Friday the 9th. Then on Saturday, you will work with your group. There will be some times when we will meet together because we have a very interesting virtual platform, really psychedelic, that we can use and meet. And there will be some facilitators and some trainings on things that are relevant for people who work together in a hackathon, like project management, leadership, or IP rights. And finally, on Sunday in the afternoon, we will have the pitches in front of the jury. We are trying to have a very global hackathon, and it's starting to be because we have international jury, people from Mexico, UK, Spain, etc. We already have some people registered, but we have still a place. The teams, 3 to 5 people. Of course, as always, we have to mix, we have to learn from each other. So ideally, if you come with a team, it should be balanced, like some legal professionals, some user experience or marketing or business development people, and some software developers. And if you are alone but you want to join, don't worry, we will try to create teams with the people who are enrolling by themselves. So be with us. I don't know if you want to add anything, because this is something we are working together. So Taimoor, Argiro, myself, and maybe I forgot some key data.
It's fine. Argiro, do you want to add something?
Hi, everyone. I'll be introducing myself, I guess. So I'm the director of Let's Lab and a senior lecturer at the University of Greenwich. And together with my good colleague, Taimoor, we're working on this project on legal tech, which has brought you all together in this second roundtable discussion. We held another roundtable discussion about 2 weeks ago, and I must say that both sessions have yielded fascinating insights. We will be collating everything in a report, and if you have any interest in this, we will make sure to share this with all the speakers and the panelists. And as Maria already said, please do make sure that you spread the word on the upcoming legal hackathon. This is on digital rights in smart cities, which will be following our symposium on digital rights, a decade of transformation. This will be the academic part. We will then finish nicely off with the legal hackathon, which will be the hands-on part. I have already inserted all the links in the chat function. And yeah, do join us.
Okay, thank you very much, Argiro. And thank you, everyone. Thank you, experts, for your invaluable time and opinions. Thank you, attendees, for joining us. And thank you, organizing team from the University of Greenwich. Thank you, our discussants. And thank you, everyone. Have a lovely weekend and enjoy the day. Take care and bye-bye. Bye-bye.